Why is Colin live?
This one is also, that's why it's here, because it's not. Does it need to sign them? Oh, I didn't sign it. All right, I see that there is a notation in here that we're looking to adjourn the settlement conference to a later date.
That is correct, Your Honor.
All right, so we're gonna set 24th, so we're looking at. February 24th is your next date.
Perfect. Thank you, Your Honor.
And as long as that works in the calendar, that's gonna be 1 p.m. again.
Yes.
And we'll see both these gentlemen by Zoom.
Okay. Thank you very much.
Take care.
You too. Thank you, Your Honor. Bye-bye.
Mr. Woodyard, you had the opportunity to speak with Mr. Johnson. Let me bring him back to the main session.
Judge, I have, and I'm going to ask if the court would recall the case that Mr. Wheeler and I were contesting, and we're going to waive our claim on that case.
All right. This is, the court is recalling case 241, strike that. Case 250151 FY, People versus Todd Johnson. Mr. Johnson, is the door closed behind you?
No, Your Honor.
All right, can you close the door?
I can ask, yes, Your Honor.
Thanks. Just pull it.
They asked if I could close the door.
All right, so hopefully that'll keep some of the extra noise out. All right, so Mr. Wheeler and Mr. Woodyard have spoken the matter. Mr. Woodyard has also spoke with Mr. Johnson. Is any of that incorrect, gentlemen?
Correct.
All right.
Correct, Judge.
All right, Mr. Woodyard, either you or Mr. Wheeler would like to bring the court up to speed on what's going on.
Judge, I've had an opportunity to speak to Mr. Johnson about the preliminary exam process, his rights, and the burden that the prosecutor faces at the preliminary examination. I think that knowing all of that, Mr. Johnson is prepared to waive his rights to a preliminary examination on this case.
Okay. And Mr. Johnson, a couple of things. One, you had the opportunity to speak with Mr. Woodyard, correct?
Yes, Your Honor.
And you and he have talked about the facts of your case. He's explained and talked to you about the statutory rights that you have to a preliminary examination. He's probably also talked to you about your constitutional rights. Is that correct?
Yes, Your Honor.
And you've been satisfied with his representation of you to date. Is that correct?
Yes, Your Honor.
All righty. And he explained to you that you do have a statutory right to a preliminary examination. At that preliminary examination, it would have been incumbent upon the prosecution, which in this case is Mr. Wheeler, to show two things. One, that there's probable cause that a crime was committed. Two, that there's probable cause that you were the one who committed that crime. And that's what they would have to show at the preliminary examination. You understand that?
Yes, Your Honor.
And you also understand that you have the right to waive that preliminary examination. You understand that?
Yes, Your Honor.
That just means that you're not saying you're guilty or anything like that. You're just saying that, okay,
Domingo Vintage.
Like department store.
All right. It may have been something else at this time because yeah. All right, here's what we'll do. No contact with that location while this case is pending, sir. Quarter set bond at 20,000 personal. Next court date is February 6th, probable cause conference, February 12th, preliminary exam, both in front of Judge Jefferson. Thank you, sir. You can step aside. Hi, what's your name, sir?
Alejandro Fitzpatrick.
And this will be case 25-055-510, State of Michigan versus Alejandro Von Fitzpatrick. Counsel.
Good afternoon, Lisa Coyle appearing on behalf of the people.
Celebrating on behalf of Fitzpatrick, Your Honor, with waiver of formal reading stand mute. He has been advised of his rights.
Thank you. Court will enter not guilty plea on your client's behalf. Ask the bond.
Your Honor, this is a safe storage case and a felony firearm. The victim in this matter is his 3-year-old son. The son allegedly has shot himself in the hand. The defendant made a statement to the police that he admitted the gun was not properly stored and that all the guns that they were located at this time of the search warrant were his. Now, I did forward a copy of this return from the search warrant to the court as well as to Mr. Reagan. In that return showed a BB gun, a 9mm with spent shell casing in the chamber, a 9mm with a makeshift silencer, and a 9mm drum, as well as another 9mm. So there's several weapons in this house. There's the gun that the 3-year-old shot himself with. Your Honor, based on the dangerousness to not only his son, which is apparent, but as well as to others, Your Honor, the people in this matter are asking for $75,000 cash surety.
Yeah, Judge, I don't know about a danger to others, or I don't really know about a danger to his son. I don't know if it was a careless judgment call on Mr. Fitzpatrick. But again, we're not here to determine that he can have 1,000 guns. I mean, that's not the issue. The issue is you gotta be safe with the gun. Kids are around. That's the real issue. And I don't know how this case is gonna play out, but I would suppose this court would tell him at this time that he has to remove all guns out of his possession. And I'd understand that, Judge. If my client has to go stay somewhere else, he I don't, if the child has to go stay somewhere else, I don't, I guess we don't have an objection. It's just it's a bad situation, Judge. We're at arraignment. I'm asking for a personal bond. I don't think a cash bond would be necessary, Judge. If you tell them not to have guns and to get rid of the guns, Judge. I'm just asking for a personal bond.
Thanks. Ms. Coyle, so the guns that were on that search warrant return, those are not in his possession, correct?
Well, no, they're in the police's possession at this point, but he did admit to all the guns were his at that residence and that the gun that was used was not properly secured. This is a law that's just taken effect based on the fact it came forward and was pushed because of gun owners that don't properly secure their weapons. This is a question here is bad judgment, and that he knows, and he admitted that he didn't properly secure his gun. That gun was found in the bedroom. There were guns all over the house. So we have a situation is that this man, Mr. Fitzpatrick, is not a young man. He's a young man. He's 31. He's not. This is a question that when a gun owner purchases a gun, it is inherently a dangerous weapon that he knows that it needs to be stored properly. And here we have a gun not only is not stored properly, it is stored loaded. So here's this child that picks up the gun and shoots himself in the hand. So for that reason, Your Honor, he is a danger because it's already inherent that a gun owner should know that that gun needs to be locked down properly, stored in a proper manner away from anybody that can get their hands on it. So for those reasons, that's why I believe that this is not just like, this is a mistake. This isn't a decision that he chose not to store his gun properly, as well as the other guns around the house, knowing that his child was going to be over there, or any other children. The cousin was also in the house. There are other people. So for that reason, Your Honor, I believe that he poses a danger to not only his child, but to anybody else that goes into a house with him, and that he has weapons around him.
Just briefly, when people make bad choices, it doesn't mean they are a danger. It just means that they may have made a bad choice at that particular time. And I don't know what the situation is with the previous, putting up of the gun or where the guns were. I mean, he said himself. I'm supposed Ms. Coyle said it was bad judgment, it was a mistake. I mean, it doesn't really danger, Judge. It just means he made a bad choice at that particular time. And if you tell him not to have guns, and he's presumed innocent. I'm not going to get into that part, but if you tell him not to have guns as a condition of bond, he won't have guns, and then we don't have to worry about the accidental. That's
all right. So here's what I'm thinking. Obviously, I don't think he did anything to intentionally harm his own kid. But we have these tragic circumstances. We're seeing them repeatedly where people aren't getting the message that they have to lock their guns up securely. And so we end up with things like what's alleged here. Sir, while this case is pending, you are not to possess a firearm at any time. Is that clear to you?
Yes, sir.
Are there any other, Mr. Reagan, any other children in the house?
He does have 4 children, Mr. Fitzpatrick. Are there kids in the house at this time?
No, my son was the only one.
But no,
Set bond at,
oh, I'm sorry, Judge.
court's gonna set bond at $20,000 personal. Next court date, February 5, probable cause conference, February 11, preliminary exam, both in front of Judge Giles. Thank you, sir. You can step aside.
Thank you.
Thank you.
Mhm. Are the walk-ins ready?
Yeah.
All right, let's do the walk-ins. DDC will come back to you in just a second. Mr. Watson. You can come up to the podium, please. And what's your name for the record, sir?
Watson.
All right. We're gonna start with some traffic tickets where you missed some court dates. When you missed those dates, a judge issued an arrest warrant for you. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and if you cannot afford an attorney, the court will provide one for you. Do you understand those rights?
Yes, sir.
All right, first ticket is C548376 with the charge of driving while license suspended. P 10410997, driving while license not valid. And P 16100527, no insurance misdemeanor. These are all misdemeanor charges. Maximum penalty you face on each is up to 93 days in jail and or $500 fine. I'm going to set aside the arrest warrants, enter a not guilty plea on your behalf, and give you a personal bond. Your next court date for the tickets will be February 24 for pretrial in front of Judge King here in 36th District. Your other matter today is 24044917, State of Michigan versus DeAndre Maurice Watson counsels, and this is an AG case.
Thanks, Magistrate.
Full record on behalf of Mr. Watson, waive the reading stand mute. He's been advised of his rights.
Court will enter not guilty plea on your client's behalf as to bond.
Judge, I ask for personal bond, just no contact with the casino.
Sir, while this case is pending, you're not to go to any Detroit casino, understood?
Yes, sir.
Court will set bond at 1,000 personal. Your next court date will be February 7 for pretrial in front of Judge Bryant, also here in 36th District Court. And if you have a seat, we'll get you some paperwork. Yeah. Okay. 1,000 person. Yeah. They, he's on a disassociated person. And your name for the record, sir? Thank you. This will be case 25044009, State of Michigan versus Khalil Tariq Kemp, counsel.
Jennifer Douglas for the people, P 72748.
Full record on behalf of Mr. Kemp, waive the reading stand mute. He's been advised of his rights, Judge.
Court will enter a not guilty plea on your client's behalf as to bond.
Your Honor, given the age of the alleged incident, the people wouldn't object to a 35,000 personal bond. We just ask for a condition of no assault of harassing or intimidating conduct.
No objection, Judge.
Are the parties still in contact?
Not to my knowledge, Judge.
Your Honor, I don't know.
I was wondering why you wanted no assault with contact as opposed to no contact. Oh, it's his nephew. Okay. All right, sir, while this case is pending, you're to have no assaultive contact with Mr. Holloway, understood?
Yeah.
Pro set bond of $5,000 personal. Next court date is February 9th for a pretrial in front of Judge Bryant here in 36th District Court. And if you have a seat, we'll get you some paperwork. Okay, DDC, we're back to you. Hi, what's your name, sir?
Trayon Leonard Cole.
Okay. All right, one moment. All right, this is case 25-055-505, State of Michigan versus Trayon Leonard Cole. Counsel.
Jennifer Douglas for the people, P 72748.
Deliberated on behalf of Mr. Cole, Your Honor, waive the reading stamp mute. He's been advised of his rights.
Court will enter a not guilty plea on your client's behalf as to bond.
Your Honor, on Trayon Cole, the people would not object to a 15,000 personal bond if there were a tether. The defendant is currently on parole according to Otis for home invasion first degree from a 2019 case. You could see in the HAB notice the various convictions, Your Honor. So there is a history here, a serious criminal history, and what's described in the investigator's report as an extensive, prolonged attempt to flee from the police. So we do think that there is a risk of flight here. So, Your Honor, that's why we are asking for a tether, but not objecting to personal bond.
Judge, I don't think there's a flight risk. I think this is a 2-year, it's a 2-year felony. He does have some priors, Judge. He's going to come to court. I don't think he misses court. He's not going to have contact with police. He's on SSI. He lives in the city, has a strong ties to the community. Don't think, again, he's a flight risk, Judge. I'm asking for a personal bond. I don't necessarily see a flight risk here, Judge.
Thank you. You said he's on SSI?
That is correct, Judge. He was walking down the street. Officers approached him, grab him, throw him to the ground, put an elbow on him. I don't see it. There's a flight risk.
A mistake.
There will be a GPS tether. Curfew on that tether will be 10 p.m. to 6 a.m. Court will set bond at $10,000 personal. Next court date is February 6th. Probable cause conference, February 13th, preliminary exam, both in front of Judge Taylor here in 36th District Court. Thank you, sir. You can step aside.
Thank you, Your Honor. Your Honor, you said tether because of the flight risk element, or I'm trying to make sure you said 10 p.m. to 6 a.m. with a GPS tether?
Correct. Good afternoon, sir. What's your name, please?
Terrence Witherspoon.
Thank you. This will be case 25-055-422, State of Michigan versus Terrence Michael Witherspoon, counsel.
Thank you, Magistrate. Steve Vincent for the people.
Right on behalf of Mr. Witherspoon, waive the reading stamp mute. Advised of his rights.
Court will enter a not guilty plea on your client's behalf as to bond.
Magistrate, we find the defendant to be a clear and present danger to everyone in the community. Respectfully, we're asking for a $25,000 cash surety. For what it's worth, we're asking for GPS tether as well as an alcohol tether. But he's got an alcohol problem, and an alcohol tether doesn't stop his problem from continuing. He also has a problem with driving while he's intoxicated, which is what happened here. And this isn't just a third offense. This is really a fourth offense because he's already been convicted of an OWI third out of Oakland in 2019. His second was in 2011. His first was in 2010. Before that, he was convicted of GBH as well as an FF. But in this particular matter, after being pulled over for erratic behavior on the roadway, he ends up submitting to a PBT, which shows that he has a blood alcohol of 0.308. And then he's taken to the hospital, gets a blood draw, which 11 days later, when the police ended up getting those results, was even higher at a 0.314. To make matters worse, he had an open bottle of alcohol in his vehicle at the time of this alleged incident. To make matters even more worse, he should have never been on the roadway in the first place because he has a revoked license. In fact, he's had a revoked license every time he's ended up finding himself in a situation regarding driving while intoxicated. So respectfully, Judge, based on his priors, based on the allegations here, based on the charges, based on the fact we find him to be a danger, we're asking for a cash bond here to protect the community.
So Judge, obviously we start with no driving. That's first and foremost. Obviously with a charge like this, that's what we look at. Now, we also look at the fact that this allegedly occurred back in September 2024, wasn't charged until, I guess, a few days ago. I understand, the concern the court may have, but I think, Judge, if you put an alcohol tether on and you say house arrest, I think that would suffice. I don't think you need to have a cash bond in this particular case. I think if a court decides they want to keep him at home, I think that would be sufficient, Judge. So I'm asking respectfully for the alcohol tether, for the house arrest, and let him come to court, and he'll have to deal with the case as he sees fit. So I'm asking the court respectfully to consider that, Judge, the cash bond.
Is your client working?
Judge, he is laid off at this particular time. He is laid off. That's correct.
All right, sir. You've got a serious drinking problem, to put it simply. You've got several prior drunk driving convictions, and you've got to do something to address your use of alcohol, and specifically your use of alcohol and then getting into a car and driving. So there will be, you're not to consume alcohol while this case is pending. There will be an alcohol tether. There will also be a GPS tether with house arrest. And bond will be set at $20,000 personal. Court date is February 6th, probable cause conference, February 12th, preliminary exam, both in front of Judge Taylor here in 36th District Court. Thank you, sir. You can step aside.
This way, thank you.
I usually would do a tether for anything that 17.
Straightforward, let's sit for the men. I'll meet you on the feet outside.
Okay, sounds good.
Okay.
This morning, they never came. Hi, what's your name, please?
JL Goodall.
Thank you. Okay, this is case 25-044-286. State of Michigan versus JL Lynette Goodall, counsel.
Lisa Coyle appearing on behalf of the people.
Deliberating on behalf of Mr. Goodall, waive the reading stamp, mute, and advise of the right.
Court will enter not guilty plea on your client's behalf as to bond.
Your Honor, I don't see a criminal history for Ms. Goodall. She's 21 years old. This is the complainant in this matter is her mother. People are not objecting to a $25,000 personal bond and no contact with her mother or her mother's residence.
No objection.
Does she have anywhere else to live?
Judge, well, yeah, she does. Judge, we want a one-time police escort if we could to get some items, Judge.
Okay. All right, you have no contact with your mother and you will have no contact with the Hull Street address. Is your client working, counsel?
Judge, she is looking for a job this week. She's scheduled to start work this week.
Yeah, I have a question. How long do it take for y'all to figure out if somebody would do this? That's my husband's Detroit Police Department. So they don't tell us somebody come to get you. You know, they come.
Are there any family members that can go get her belongings?
Yep, so after we get your court papers, we take all paperwork.
That's Judge. Are there any family members Goodall that can go and retrieve some of the belongings?
You said, will I be able to go retrieve some of them?
No, I said, do you have any other family members that could go retrieve some of your belongings?
Yes.
Okay. All right, no contact with your mother, no contact with Hall, and bond will be $5,000 personal. Next court date is February 3rd for pretrial in front of Judge Garrett here in 36th District Court. Thank you. You can step aside.
Okay, you good, you can go back out there and have a seat.
You said the bond is 5,000?
You'll get all that information whenever you get released. thought they said 10%. You don't have to, yeah, you don't have to.
Please,
You don't have to pay.
Oh, I gotta know, that's what I'm gonna ask. So I'm
Next
gonna-
lady on the bench.
next young lady, please.
So if I.
Come on, Miss Shaw.
Okay, cause I know, I'm sorry.
Hi, what's your name?
Sharice Shaw.
Thank you. So we're gonna start with some traffic tickets you have when you miss some court dates. On these tickets, a judge issued an arrest warrant for you. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and if you cannot afford an attorney, the court will provide one for you. You understand those rights?
Yes.
All right, first ticket is P 1369521 with charges of driving while license suspended and no insurance misdemeanor. Ticket P 1456822, no insurance misdemeanor. And X 4085329, no operator's license and invalid insurance or invalid certificate of insurance. These are all misdemeanor charges. Maximum penalty you face on each is up to 93 days in jail and or $500 fine. I'm going to set aside the arrest warrants, enter a not guilty plea on your behalf, and give you a personal bond. Your next court date is a pretrial on February 24 in front of Judge Sherman here in 36th District Court. Your other matter today is case 24-045054, State of Michigan versus Sharice Yvonne Shaw. Counsel.
Samuel A. Writing for the people, Your Honor.
We'll bring on behalf of Ms. Shaw, Your Honor, waive the reading statement, advised of the right.
Court will enter a not guilty plea on your client's behalf as to bond.
People are asking for a $25,000 personal bond. Very, very serious matter. She was 30 miles over the speed limit, 85 and 55, and her PBT was 0.14. But no other priors, Your Honor. Thank you.
Yeah, she turned herself in, but she found out about it. We'd asked for the personal bond.
Ms. Shaw, while this case is pending, you were not to consume alcohol at any time. Is that clear?
Yes.
Court will set bond at $10,000 personal. Next court date is February 7 for a pretrial in front of Judge Bryant. And I have a note time. Counsel, does their client work?
Hold on, sorry, give me 1 second. Yeah, she was doing security. She was doing security, working as a security guard.
Okay, February 7th is a pretrial in front of Judge Bryant. You're all set, ma'am. You can step aside.
Thank you, Your Honor.
Thank you, Your Honor.
What was the court date? February 7th. Are you so back over there?
Is that it, Tron?
There should be a Brittany Benson.
It looked like that was a Zoom case.
Was that right? Oh, yeah, you're right. And she didn't zoom in. So yeah, I guess that's it.
Okay. Thank
Have a
you.
good evening, everyone.
Everybody have a good evening.
Good evening.
Yeah.
Thank you.